Here with a special guest we have with us today, attorney Joshua Schiffer, joining us. Thanks for being with us, Josh. Look, so the reason we're on here today is because there are some major new developments in the YSL trial, also known as the Young Slime Life Gang racketeering and RICO trial. I mean, we actually just had a whole debate on what exactly we should be calling it. But look, the major development here is that a jury is finally starting to be seated some 11 months into jury selection. We know that jury selection began earlier this year in January. It's been a historically long jury selection, and we've learned that right now jurors are being stricken or striked, depending on
selected.
Selected. They're being selected, but jury selection has been going on throughout the year. But what's happened now is that basically the attorneys on both sides are whittling down the finalists, the 12 jurors, and then the several alternates who are actually going to hear the case in chief. So, Josh, you know all about this. What does this mean?
Yeah, let me give a quick summary because today's a big mile marker day in what is going to end up being one of Georgia's longest trials, if not the longest trial in the history of Georgia. Today, in the Young Slime Life or Young Thug trial going on in Fulton County, Judge Ural Glanville has 48 jurors that have all been approved and selected. So now the actual prosecution and defense attorneys are going to go back and forth exercising what are called juror strikes, and they're going to strike or remove jurors until they get down to the final jury that's going to hear this case in chief. And what we're hearing is that's going to begin on or around November 27th. There's going to be 12 frontline jurors and then one or more alternates, because remember, this trial, they're thinking about 5 months of actual trial. A good chance that something might happen, so those alternates are a good idea.
Okay, and I just want to kind of zoom out a little bit, because Josh, you and I met through Court TV when I was working at Court TV, and you were a regular guest analyst there. So I want to just assume that not everybody follows court cases inside and out, gavel to gavel, the way that we have. So just kind of backing out, what we've done the last few months, 10 months, is jury selection, right? What's also known as voir dire, where jurors prospective jurors are chosen from the community. And then what we had when we started the day was about 50 or so potential jurors. And what's happening is that each side is basically exercising their right to strike, both the defense and prosecution, meaning they can essentially eliminate a juror because they believe that juror may be biased. Is that correct?
Yep, that's absolutely correct. And like you said, for the last 10 or 11 months, we've been going through the juror qualifications portion of the voir dire process, which is where hundreds, if not thousands of Atlantans have filled out a 37-page questionnaire and gone through qualifications to find out whether they're eligible and appropriate to sit as jurors, or at least to go through the final stages of jury selection, which that's what started today. All the jurors that were listed are qualified, and they are going to be whittled down using jury strikes, where either the defense, and there are 7 defendants, or the state says that juror, we're striking them from who we would consider. And as that 48 goes down to 40, goes down to 30, eventually, they're going to end up at the final jury and alternates that will hear this trial.
Okay, and then, you were mentioning the case in chief beginning November 27th, which I guess would be after Thanksgiving. Is that the Monday after Thanksgiving?
That's the way I've got it.
Okay, so when we talk about the case in chief, it's like, you watch on TV that the court has adjourned and the judge is present, and the defendants are present with their attorneys and the prosecutors present, and you got the jury sitting in the jury box and all that kind of thing. You watch that on TV. So we haven't gotten to that point yet. Right now, we're just choosing who's going to sit in that jury box. But the case in chief beginning November 27th, that is when we're actually going to start hearing opening statements from the attorneys. Again, we're working to confirm this information, and this is a very fluid situation, but November 27th, just after Thanksgiving, is when we have heard that the opening statements could actually begin, where attorneys lay out their overall case, correct?
Yes, it's what people think about when they think of trial, where the state and the defense will each present their openings. We will then have weeks of witness presentations, first from the prosecution, followed by cross-examinations by the defense, and then we reverse it. The defense gets to put up their defense, and the state gets to cross-examine. Then we're going to get to closings, then a verdict. The estimates right now are 5 months for the actual trial, which is an extraordinarily long time frame, but this is an extraordinarily unique and complex case.
And I have a question for you, Josh, because you have so much experience practicing in the state of Georgia, practicing law in the state of Georgia. Does the state then get to put on a rebuttal case after, like you said, prosecution is going to lay out their case, defense is going to lay out their case? Does the prosecution get to go back up again and lay out a rebuttal case?
Yeah, there's absolutely going to be an opportunity for the state to come back and answer part of what the defense is going to bring out. There's oftentimes a strategic issue with reserving arguments. It used to be that the defense had what some people claimed was an unfair advantage when it gets to primacy and recency in front of a jury. Allowing the state some rebuttal has addressed that. The most important thing to remember is the hearings over the next couple of weeks, those pre-trial motions hearings. Those are going to set the landscape up for what will eventually be a knockdown, drag-out trial. These are some of the best lawyers in the state, and they've been working on this for a year, all while their clients have been incarcerated.
And a lot of these motions have centered on, especially the ones that are garnering public attention, have centered on rap lyrics and whether rap lyrics can be used as evidence of the alleged racketeering and other criminal charges.
A complex and novel issue, and this is one of the bellwether cases. The entire criminal defense universe and criminal prosecution universe is watching. That's because DA Fonnie Willis, through Miss Love and the rest of her team, has specifically set out, and these motions were recently filed, individual particularized lyrics from the music produced by the Young Slime Life groups, and they are trying to use those as basically admissions, which are always admissible, admissions of criminal street gang activity, violent activity, acknowledgement of participation in violent street gang crimes. And that is a unique angle that DA Willis is going down. The defense is obviously fighting back. The arts and entertainment community is very upset, thinking that a song lyric, something that is theoretically fiction, is now going to be used to prosecute an artist. And that's a difficult legal question. A lot of good questions on both sides need to get answered.
And what would be the legal argument for the defense? Is it that this is a kind of protected free speech? I mean, or, free speech can still, obviously, we're free to say whatever we want, but that doesn't mean that in a regular criminal trial it can't be used as evidence that we committed a crime, right?
And you've honed in on exactly the issue. The state's position is that all of these lyrics were spoken and that these speakers have free speech and that anything you say can be used against you when you get to evidence and court. And so the state's saying, hey, they sang about all this and they're allowed to explain these lyrics all they want because all defendants have the right to speak during their trial. But the state also argues they have a right to take these lyrics and show how they are connected to the underlying allegations contained in the indictment. And remember, this indictment involves criminal street gang behavior. The allegation is that the original 27 individuals all worked in conjunction in an overarching conspiracy to run a racketeering and corrupt organization, the state believing these lyrics are proof of that organization.
And so the defense argument is essentially that that lyrics are fiction, that they're not necessarily factual.
Bob Marley saying, "I shot the sheriff." He didn't. So did Eric Clapton. He didn't either. And that's exactly what the defense is saying. These are works of artistic merit. They are not admissions of any factual action, and that they are purely an artistic expression from a producer. They should not be allowed to be used against them in a prosecution. Now, the state's response to that is, you're allowed to put them in context all you want. You're allowed to talk about how you are an entertainer, and these are your entertainment products, but it doesn't prevent them from being admissible. The question's over the weight of that evidence as opposed to the admissibility reliability of that evidence.
And then basically the prosecution would argue, leave it up to the jury really to decide whether, they meant it as, a kind of a matter of fact, or if it was just a form of artistic expression.
Absolutely, because some of these lyrics are really aggressive, and they seem to, if you view them in one particular light, directly address the allegations of clear illegality contained in the indictment. We're talking about violent imagery, talking about murder, harm, drug dealing, all kinds of things that a jury would be biased by if they heard. And there's a realistic worry from the defense that how can a juror find for a defendant when they've heard the defendant sing about participating in exactly the kinds of crimes the state is alleging.
Gotcha. So, Josh, right now the strikes are going on, right, for the jurors. Just taking it back to the moment that we're in right now, that means that a jury could potentially be seated. It could happen today.
For all I know, that jury could be seated in a matter of moments into an hour or two. It is a relatively quick process now that all of the jurors have been qualified, and it's going back and forth. It literally, when you go through it, oftentimes looks just like a piece of paper passing between two tables, and a deputy walks the piece of paper back and forth as the lawyers strike their individual jurors by number. The state strikes number 3, the defense strikes number 14, and then when you get down to the proper number of jurors, that's your jury. A lot of America believes that the jury process is inclusive, and you're choosing a jury. The absolute opposite is true. Jury selection is an exclusionary process where you are kicking people off of the jury because you're afraid of them.
And what would be the reasons that lawyers, number one, I should say, strike a juror, and number two, say that they strike a juror, because they may not say what they think.
Yeah, and it is as much art as science. There's a lot of gut feelings. You can read all kinds of books talking about how jurors are supposed to vote, but that's really an exercise in discrimination and prejudice. It's an exercise in choose a selection. Select a person based on very limited knowledge and your feelings about them and how they would approach your case, having only been exposed to them during the selection process. So there's a lot of chance and happenstance. There's also a lot of gut feeling and gut connection.
Got it. All right. Well, thank you so much, Attorney Josh Schiffer, for your insight and analysis. And again, just reiterating for our viewers, we are watching closely because the jury is starting to be seated finally 11 months in to jury selection for the YSL trial. And as Josh and I have just been discussing, this could even happen today. A jury could even be seated today. So if you haven't done so yet, really encourage you to just download our Atlanta News First mobile news app so you can get updates sent right to your phone. Keep it right here on Atlanta News First or Atlanta News First Plus, because we're going to keep following all the breaking developments. Have a great day.